Previously on the Constitutional Record. In Episode 1, Jack Smith testified to, quote, proof beyond a reasonable doubt, unquote, that Trump committed crimes. In Episode 2, we saw that 57 senators, a majority, voted to convict Trump of inciting insurrection. It wasn't enough. Mitch McConnell, after voting to acquit, said there was, quote, no question, none, unquote, that Trump was, quote, practically and morally responsible, unquote. Impeachment failed, but the criminal cases were moving forward. Then came July 1st, 2024. Welcome back to Ethos Track. I'm Sarah. This is Episode 3 of the Constitutional Record, a king above the law. That phrase isn't mine. It's from Justice Sonia Sotomayor's dissent in Trump v. United States, the Supreme Court decision that fundamentally changed what it means to hold a president accountable in America. Today, we're going to look at what the court actually ruled, what the dissenting justices warned, and what constitutional scholars say about a doctrine that appears nowhere in the text of our Constitution. This was the case. Trump v. United States arose from Jack Smith's election interference prosecution. Trump's lawyers argued that he was absolutely immune from criminal prosecution for any actions taken while president. The theory? A president cannot function if he's worried about future prosecution for official acts. The district court rejected this argument. Judge Tanya Chutkan wrote that the presidency does not, quote, confer a lifelong get-out-of-jail-free pass, unquote. A 3-judge panel on the D.C. Court of Appeals unanimously agreed. They wrote that if Trump's theory were accepted, it would, quote, collapse our system of separated powers, unquote, and put a president above the law. But Trump appealed to the Supreme Court, and the Supreme Court took the case, a decision that by itself delayed the trial past the 2024 election. The decision. On July 1st, 2024, the last day of the term, the Supreme Court issued its decision. 6 justices in the majority, 3 in dissent, split along ideological lines. Chief Justice John Roberts wrote the majority opinion. Here's what they held. First, presidents have absolute immunity for official acts within their, quote, core constitutional powers, unquote. This includes things like the pardon power, command of the military, and, critically, control of the executive branch, including the Justice Department. Second, presidents have presumptive immunity for all other, quote, official acts, unquote. This immunity can only be overcome if prosecutors prove that prosecution, quote, would pose no dangers of intrusion on the authority and functions of the executive branch, unquote. Third, presidents have no immunity for, quote, unofficial, unquote, or private acts. The court sent the case back to the lower courts to determine which of Trump's actions were, quote, official, unquote, and which were, quote, unofficial, unquote. But here's what matters. The court specifically ruled that Trump cannot be prosecuted for his efforts to use the Justice Department to pressure states about the election. Why? Because a president's interactions with the DOJ are within his, quote, core constitutional powers, unquote. Using the Justice Department to overturn an election? According to 6 justices, that's immune from prosecution. The dissent. Justice Sotomayor's dissent, joined by Justices Kagan and Jackson, is one of the most significant dissents in modern Supreme Court history. She wrote, quote, "Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent," unquote. Let's pause on that word. Treasonous. A sitting Supreme Court justice used the word, quote, treasonous, unquote. She continued, quote, "Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity," unquote. And then the line that should echo through history, quote, "The president is now a king above the law," unquote. Justice Sotomayor concluded her dissent with 3 words that broke with tradition. Justices typically end dissents with, quote, "I respectfully dissent," unquote. She wrote simply, quote, "With fear for our democracy, I dissent," unquote. Justice Jackson's warning. Justice Ketanji Brown Jackson wrote separately to emphasize what the majority had done. Quote, "Under the new presidential accountability model, the starting presumption is that the criminal law does not apply to presidents, no matter how obviously illegal, harmful, or unacceptable a president's official behavior might be," unquote. No matter how obviously illegal, no matter how harmful, no matter how unacceptable, the starting presumption is now that the criminal law doesn't apply. What the Constitution actually says. Here's what's constitutionally significant about this ruling. The founders knew how to write immunity language. They did it for Congress. Article 1, Section 6 contains the speech or debate clause, which gives legislators immunity for legislative acts. The founders explicitly protected Congress from prosecution for what they say and do in the legislative process. They did not write similar language for the president. The Constitutional Accountability Center puts it plainly, quote, "The text of the Constitution provides a form of immunity for legislators under the speech or debate clause, but not for sitting or former presidents." In other words, the framers knew how to draft immunity language, but chose not to do so for presidents, unquote. They knew how to do it. They chose not to. The Supreme Court created presidential immunity from nothing. There is no textual basis for it in the Constitution. The framers' intent. The founders were explicit about presidential accountability. During ratification debates, James Iredell, who would later become a Supreme Court justice, said the president was, quote, "punishable by the laws of his country," unquote, and, quote, "not exempt from a trial," unquote. In Federalist 69, Alexander Hamilton distinguished the American president from the British king, specifically on the question of accountability. The king could do no wrong. The president, Hamilton emphasized, could be impeached, removed, and then prosecuted. And there's a historical example that proves the point. When Gerald Ford pardoned Richard Nixon in 1974, he did so specifically because Nixon could be prosecuted after leaving office. The pardon would have been unnecessary if former presidents were immune. Ford's pardon proclamation acknowledged that Nixon faced potential prosecution. The pardon was the only thing that prevented it. That's how everyone understood presidential accountability. Until July 1st, 2024. The practical effect. The Brennan Center for Justice summarized what this ruling means. Quote, by inserting this opinion into a world where impeachment is no longer a viable option, the Supreme Court is licensing future presidents to subvert our democracy at will, and protecting a past president, Donald Trump, who attempted just that, unquote. Think about the logic. Impeachment requires 67 Senate votes, nearly impossible in a polarized era. Criminal prosecution is now blocked for, quote, official acts, unquote. So what's left? The court essentially said, if you can frame your conduct as official, as presidential, you're immune. And you don't even have to get away with it. You just have to be president while you do it. Here are today's questions. 1. The Constitution explicitly gives immunity to legislators in the speech or debate clause, but says nothing about presidential immunity. What does it mean that the court created this immunity anyway? 2. Justice Sotomayor warned the president, quote, is now a king above the law, unquote. Is that hyperbole? Or does the immunity framework support that conclusion? 3. If impeachment requires 67 votes and prosecution is blocked for official acts, what mechanism remains to hold a president accountable for conduct in office? The impeachment mechanism failed. The criminal prosecution mechanism was blocked by the Supreme Court. But there's more to this story. On January 20th, 2025, hours after taking office, Donald Trump pardoned approximately 1,500 people charged in connection with January 6th, including people convicted of seditious conspiracy, the crime of conspiring to overthrow the government. In our next episode, Seditious Conspiracy Pardoned, we'll examine who was pardoned, what seditious conspiracy means under federal law, and what judges and prosecutors said about what the pardons represent. That's Friday, right here on Ethos Track. I'm Sarah. The full text of the immunity decision and the dissents are linked in the Substack companion.